I was saying that the Office of the Director of Public Prosecution, the message that basically is communicating on the strength of this indictment is to the effect that despite your fervent efforts to come up with some kind of evidence in the case docket and probably in your memorandum to the effect that this could have been a hit or contractual killing, in their mind, having gone through that evidence, the docket and the memorandum and whatever that they could have took into account in coming to this decision, they could not find any evidence that they can bring to court to proceed against this accused person on charges based on the fact that this was a contractual killing.
Athi wadabona ukuthi bona-ke ithimba le-ofisi abashushisi abakhulu-ke uma ngabe kade bebuka ke memorandum lapho-ke futhi nedocket le kade bonikise kubona-ke ngesikhathi kade beqeda ufunda-ke bese bathatha-ke isinqumo lapho-ke bese bona bacabanga noma mhlawumbe baphuma nesinqumo sokuthi-ke lokudutshula kukamufi noma lokushona kamufi ngesikhathi kade kusenza kudlame noma bugebengu lobo-ke noma isigameko kukuthi kade kuyinto kade ihleliwe phansi phakathi kwabantu ababili noma abantu ekwiqembu.
My lord, I'm not sure. That's not what I was told. I'm not sure if I can say they told me that they didn't find any evidence. That's why I said that's not my terrain, and I think it's best that. But to say or in a session that suggests that they were of the view that there was no evidence, I'm not so sure if I can agree.
Who said that? According to Mr. MNISI,
he says it's the DPP. He doesn't give me a specific name.
Thank you.
So you're denying it, in other words?
Because that's not what I was told, my lord. I don't have
never
that
told.
position. No, I was never told that they don't see any evidence.
Athina abakaze bamtshela ukuthi abukho kufakazi obukhonayo lapho-ke futhi ade bebuza ukuthi ngabe ubani kosho lo nkulumo leko athi yena-ke bamtshelile igama lomuntu othizile noma igama lomuntu elikhethekile-ke mayelana nalolo daba lolo-ke.
Thank you, Brigadier. I'm referring this, I'm saying this in the context of what I explained to you earlier on about me saying the DPP said to you. I think we're still on the same line with regard to that.
But kukhuluma manje nodaba lolu bekakhulumile ke ngalo esikhathini esendlule ngaphambi kwesihambise esikhathini sokudla sasemini-ke la athi khona-ke bayakhuluma ngodaba labasebenzi balapha-ke ehhovisi le-DPP office shuthi abashushisi abakhulu.
Yes.
Wait. So what you're putting to this witness, it's your own imagination.
No.
No, listen to me.
I'm not imagining things.
No.
Okay, maybe the court can finalize.
No, just repeat that question because it's similar like the question you put to this witness, because you are making an incantation that this witness was there when the Director of Public Prosecution and his staff were planning the modus operandi, like for instance saying that they don't find that there was a contractual killing. And this witness says he never discussed that. But you are putting it as a fact. You are putting it as a fact.
May I respond?
Yes, respond.
Thank you.
Oh, good.
Earlier on said, my lord, to the witness number one, that please, you should not understand me in a
No, I heard you, and that's incorrect to cross-examine a witness like that. That when you are talking about a particular individual in an office, it doesn't include him. No. If it includes him, you must tell him, on such and such a day, you were in the DPP's office, there was so and so and so and so, and you talked about this and this and this, and this was the decision.
Thank you, my lord.
Not the suppositions you're putting to him. That's not evidence.
Thank you, my lord.
Yes.
Brigadier, it's very simple. Now, the Office of the Director of Public Prosecutions, I'm no longer saying that they said to you this and they did not say to you that. But the Director of the Office of Public asking now, the Office of the Director of Public Prosecutions then took a decision that did not align with your motivation and your investigation is contained in the docket that this was a contractual killing. And I am not thumb-sucking that. This is no imagination. This is what is contained in the indictment that this accused person were called upon to come and plead to.
Athi-ke manje-ke akasakutshela ukuthi ithimba labashushisi noma ihhovisi labashushisi abakhulu lakutshela ini noma bakaze bakutshele ini-ke lapho-ke kepha athi yena bona-ke abakaze bathi lokushona kukamufi kade kuyinto behlezi phansi ehleliwe noma kukuzwana phakathi kwethimba labantu ababili futhi ubheka phezulu-ke lapho-ke kepha athi-ke bona athi yena-ke lapho mayelana nodaba olubhaliwe ngaphansi kwenkulumo noma ngaphansi kwencwadi bathi indictment loke ngesingisi la bathwesa khona-ke abasolwa amacala noma yebo la bathwesa khona-ke abasolwa amacala-ke kusinqumo sabo lesi abafika kusona malana nodaba olubhaliwe ngaphansi kohlelo lwe-indictment.
I disagree, my lord. Perhaps the right connotation should be not completely aligned, but to say it's not aligned, I disagree. Because in the memorandum, accused 1 up to 5 was presented, and the DPP arraigned them. And that's a different situation when it comes to Kelly Kumar, and that is why I said that's not my terrain. But to say it's not aligned, it will simply mean even accused 1 up to 5, I made no presentation to the DPP. So that's not correct, my lord.
Athi akhona-ke iqiniso lelo kepha ngeke asho ukuthi akuhambisane-ke lokho malana nenkulumo kammeli wenu la ekhulumile athi lapho-ke isinqumo esaqhamuka phakathi kwehhovisi labashushisi abakhulu-ke ekuthizeni-ke bathwese abasolwa-ke amacala umsolo wokuqala umsolo wesibili wesithathu nesine wesihlanu-ke kungemuva kokuthi kade befundile ngaphakathi kwedocumente futhi nedokhethi futhi memorandum ngoba khona lapho kade bebhaliwe futhi befakiwe kepha-ke isimo sabo-ke siyehluka-ke nesimo sakaKhili Khumalo.
Yeah, for my edification, do you, Brigadier, do you write out section 105 notes concerning what the state is going to prepare or propose in this matter?
No, I don't, my lord.
Because in terms of section 105, the prosecutor has to align the allegations against the persons who have been indicted, and he will present factual analysis that the evidence of the state is going to be A, B, C, D, E, F, G. And in terms of the law, here's the thing. In terms of the law, he's got to do it because we are appearing in the High Court.
Manje-ke inkosi enkantolo kade ibuza-ke kufakazi ukuthi ngabe-ke lapho-ke uma ngabe wabhala yini-ke ama-notes-ke lapho eqhamuka ngaphansi komthetho-ke section 105 lapho-ke la kuvame ukuthi khona-ke esikhathini esiningi uma ngabe hlangothi lezoshushiso-ke uma ngabe sebezokuhlala la icala ngaphambi kwenkantolo-ke kulaba vame ukuvala khona ukuthi nawo amacala ahambisanayo futhi amacala esithwesa-ke abasolwa-ke lapho-ke ngemuva kwalokho sebathi-ke nawo ubufakazi esinabo-ke ngalana-ke futhi nabofakazi nabo abofakazi sobaletha nofakazi sinabo malana nabasolwa malana namacala la kusube esikhathini zakhona-ke bebathosa wona.
Yeah, let me read it so that people know that I'm referring to what. Section 105A, prosecutor may address court and adduce evidence. The prosecutor may at any trial, before any evidence is adduced, address the court for the purpose of explaining the charge and indicating without comment to the court what evidence he intends adducing in support of the charge. 150 subsection 2A. The prosecutor may then examine the witness for the prosecution and adduce such evidence as may be admissible to prove that the accused committed the offense referred to in the charge sheet, or that he committed an offense, an offense of which he may be convicted on the charge. 152B. Where any document may be received in evidence before any court upon its mere production, the prosecutor may read out each such document
in court unless the accused in his possession of a copy, is in his possession of a copy of such document, or dispense with the reading thereof. And this is written by the prosecutor. And I take it, when I say the prosecutor, it's through the office of the DP, Director of Public Prosecutions. Do you take part in such an analysis?
No, I don't, my lord.
Okay. Yes, sir.
My lord, I am not saying that it would never be my submission that this witness, or my argument, that this witness, when the office of the Director of Public Prosecutor takes a decision, it gets to be party there too. No. I am only putting to this witness, as a method of cross-examination, the gist of what the Director of Public Prosecution's decision is in relation to the trial that we are standing, in relation to the trial that we are busy.
That's fine. Me, for my edification, I had to understand whether he does that or not. There could be prosecutors who do that, and there could be investigating officers who do that. But I'm telling you what the law says should happen before the case is commenced with. Because the law says the accused himself must be apprised of the allegations which are contained in the indictment against him. And there's a duty on the prosecution to summarize that type of evidence. And I am asking that because it has been put to you, for instance, about that evidence. There was evidence which purports to support a contract killing. Are you with me?
I'm with you, my lord.
Fine. So it's not against anybody. I just want to understand the modus operandi of how the prosecutor, the Director of Public Prosecution, that is, after signing this document called an indictment, what is encapsulated in it. Okay.
Thank you, Madam. Now, Brigadier, probably I need to sum this up. I definitely need to sum this up. Now, in respect of the document, which is called an indictment, that, an indictment, it's a document that is used to bring this, not really bring, it's a document that introduces this accused to the court and the allegations that are against them. In other words, it is a document that gets presented to the court. The court is informed that these accused persons that we're bringing before you are not here for something else other than what we've mentioned in the indictment.
Athi-ke uma qedela ke inkulumo yakhe-ke nje ngokunciphile-ke ummeli usho ukuthi udaba lolu lwencwadi-ke babiza ukuthi indictment ngelimi lesingisi-ke indictment kula khona kubhala khona kamagama abasolwa futhi namacala la bawathwesa bona-ke noma amacala ekusuke ukuthi bathweswa wona abasolwa-ke lapho-ke bathi inkulumo nje leyo ejulile futhi nje enciphile nje ngokuncane-ke lapho-ke la kubhala mayelana namacala abathwesa bona-ke futhi nesizathu sokuthi kungani phambi kwenkantolo kusuke singaphakathi kwale indictment okuthizeni amacala ababhekene nawo ngaphambi kusenkantolo ekuthizeni kusenkantolo iyazi ukuthi uma ngabe sesiletha abasola phambi kwayo-ke kumele yazi ukuthi labasola yini le noma yisathu sini-ke leso esenze ihlangothi lezoshushiso ekuthizeni balethe abasola ngaphambi kwenkantolo.
I'm listening, my lord.
Thank you.
Athi yebo ngilalele.
Now, in that document, the Office of the Director of Public Prosecution, having gone through the evidence that you had submitted to them for a decision, they could not find reasons, for whatever reasons that they could have heard, they could not find those reasons to align themselves with the investigation that says that this was a contractual killing.
Yes, Malad. You've already made an objection against this line of cross-examination, and just not to disturb the flow of proceedings, we're not going to make repeated objections, but I just want to draw my colleagues' attention to section 144, subsection 3, which says the indictment must be accompanied by a summary of substantial fact, but that those summaries are not binding on the state. Evidence is presented to the court on the basis of which a decision is made. The summary of substantial fact is not binding on the state.
Yeah, but read it so that it's on record. You will find that there are certain judges who don't know what you're talking about.
The heading is trial before Superior Court, section 144, charged in Superior Court to be laid in an indictment, subsection 1, where an Attorney General, that's now the Director of Public Prosecution, arraigns an accused for sentence or trial by a Superior Court. The charge shall be accompanied in a document called an indictment, as my colleague has pointed out, which shall be framed in the name of the Director of Public Prosecutions. 2. The indictment shall, in addition to the charge against the accused, include the name and, where known and where applicable, the address and description of the accused with regard to sex, nationality, and age. And this is now the section that we are referring to, this is subsection 3A, where the Director of Public Prosecutions under section 75, 121, 3B, or 122, Roman figure 1, arraigns an accused for a summary trial in a superior court. The indictment shall be accompanied by a summary of the substantial facts of the case that, in the opinion of the Director of Public Prosecutions, are necessary to inform the accused of the allegations against him, and that will not be prejudicial to the administration of justice or the security of the state, as well as the list of the names and addresses of the witnesses the Director of Public Prosecutions intends calling at the summary trial or on behalf of the state, provided that, Roman figure 1, this provision shall not be so construed that the state shall be bound by the contents of the summary. That is the point that we're trying to make.
Okay.
May I respond?
Yes, yes.
Thank you. And my Lord, I am not here to blow my own trumpet.
You must blow it.
No, I can't. That's not in my nature.
That's so.
Yes. It is definitely not in my nature, my Lord. But let me bring the following to the attention of the court. All that my colleague has been reading here must be understood contextually. When that section says that the Director of Public Prosecution or a prosecutor is not bound by the information in the summary of substantial fact, this is what is being referred to. Remember the indictment, my lord. Indictment is a substratum. In other words, it's a foundation of what these accused persons are here, or for the reason why accused persons have been brought to court. Now, to give a bit of a brief summary of why the accused are before court, then the legislature came out with that summary of substantial fact. In other words, the legislature saw it necessary to inform the court that, you know what, when you say that this person has stolen, the court must not be seated there and wondering whether this person has stolen cows, or this person has stolen a motor vehicle, or he has stolen ships or whatever. The court must already have a clue that, when the prosecutor says that the person that is appearing before me is charged with theft, I I must know that I will have to listen to evidence that is dealing with the theft of a motor vehicle.
Does it follow, sir?
I'm still addressing the court.
Oh, I see.
Thank you. That is basically the intention of a summary of substantial facts. But the foundation, where is the foundation? The foundation is in the indictment itself. The indictment that is speaking about theft. That clause that says that a prosecutor is not bound by the summary of substantial fact, it simply refers to how can I put it? It simply refers to simple modalities as to when could the theft have happened, as to how the theft was committed, as to who was again involved in the theft and stuff like that. But you cannot change the substratum, the foundation, and say the indictment says this is theft, and then come and say when you're leading evidence and say no, but this was murder. You can't do that. Because then you are changing the substratum. In other words, in an example of a house, my lord, a house has got a foundation, which is the indictment. Then the summary of the substantial fact are the simple modalities of the house. You can play around with where you want to go and fit the window, what should be the color of the house, whether you wanted the roofing there to be tiled roofing or corrugated iron or thatch roofing. But you definitely cannot change the substratum. That is what an indictment is, my lord. An indictment is a foundation, which is why in terms of section 35(1),
But that's about section 74. You quoted section?
no, that's 144, my lord. Yes.
What section?
Section 1443.
1443.
Yes.
That's what he's quoting. Now you're describing some other.
No, my lord, that is exactly that. Which is the reason
Okay,
why
I'll read it for myself because this is not what 144 says. I'll read it for myself. Okay, you can quote it, whatever you want to quote.
this is the reason why, my
I'll
lord.
read it for myself. And
Yes.
I think I understand to read English
Yes, my lord.
because here it says we are not bound. We are not bound.
But that
It's
is
an absolute prohibition. We are not bound.
that is what I'm
Okay,
trying
fine. You heard me.
that is what I'm explaining, my lord.
No, fine.
That is what I'm explaining. That we've got the indictment, which is a foundation. We've got the summary of substantial fact that tells the court what the indictment is all about. But if the state in the indictment has included something like time, which is not right, probably it will say on and about the 7th of October 2019, and at about 10 o'clock in the evening, this theft happens. And the evidence says, no, this theft actually happened at about the 10th of October 2019 at around 4 in the afternoon. Those are just simple modalities. You cannot change the substratum. You cannot change that you are dealing with a theft of a motor vehicle. That is exactly what section 114 says when it says the state is not bound. But it does not simply mean that willy-nilly the state can change from saying this is a theft of a motor vehicle and say now this is murder. That is the issue that I am getting to.
You are addressing your colleague. He's got to respond to you.
Yes.
Fine.
Thank you, ma'am.
If you are ready to respond.
Yes. As a court, please, my lord.
Then the court says I'm accusing my colleague if he's ready. Then he can respond. The court does not even verify with me if I'm done or what.
I asked you.
No, but
I did. Didn't I ask?
no, I did not hear the question.
Yeah, you didn't hear the question. Fine. Go on.
And what was my answer, madam? Whether I was
The
done
answer
or
is
not?
you are not done.
Yes. But now I'm getting perplexed that
No, just
all
go
of a
on.
sudden they're going to
Mr.
start
Please.
Mr. Baloyi to
Mr.
stay
Please.
when I'm...
Just proceed.
Sometime.
No, proceed with your case. Proceed with your case.
I'm done, man.
Oh, now you're done. Fine. Yes, he says it's done. Can you respond if you have any response?
Yes, my lord. I think with the greatest of respect, my learned friend is putting the cart before the horse. Facts are presented before the court and evidence is led, and at the end of all the evidence, a decision must then be made based on the facts that have been presented. Now, he wants to bind the witness to a view that he held at the time. That's not evidence. A decision must be made on the evidence that will have been presented before the court at the conclusion of the trial. It's an argument that he can present at the conclusion of the case, not at this point in time. Evidence is still unfolding, my lord. We submit with the greatest of respect that that is not for this witness to answer that, but it will be based on the evidence that is presented before this court.
That is so, my lord. That is so. But remember the testimony of this witness. I cannot simply leave it hanging, my lord. Because it is because of this witness that these accused persons are here at court. So for all intents and purposes, I'll have to go through his evidence like a comb and step by step. I'm not so sure if there is anything in law that forbids me to do that. And if there is any, may I please be, my attention be drawn to the thing, my lord, or to that authority. Thank you.
Family, what do you think about what MNISI has been lecturing in that court? Because it seems like to Baloyi and the judge, it doesn't sink into their mind as to how this indictment was drafted, because it doesn't link up these people. The case that they are in there, it's kind of like crazy that MNISI would come today and come and tell them that this is not linking the 5 accused, because the indictment that was done there, it was done wrongly. So, family, I don't know. What do you think about MNISI? He was on fire and he could not take no nonsense, because he proved that he knows his story like any other thing. Oh my God, I couldn't even believe MNISI was this kind of MNISI who was on fire. I felt like Mngomezulu was in the court, because normally Mngomezulu used to keep that court alive. But now MNISI is there. He's just doing an amazing job for his client. I don't know what you think, family. This MNISI is so powerful. And he's challenging all of them. No matter how much Baloyi is jumping, trying to object, and whatever the judge is trying to bring up and read some kind of clauses in the law book. But to MNISI, he's always having answers without opening those books. So, family, what do you think about what MNISI is doing in court? I think MNISI is doing a very good job for his client. And it doesn't look like, oh, he's not paid by him, but he's paid by government, for his client. But the fact that our tax money goes to somebody who stands for his client like this, it helps to understand, because sometimes they just they just go over, they don't care. Some of them, they just, because they are not paid by that person, whoever that accused is. But once you get this money from government, because it's not in their scale. So, family, I think MNISI deserve a lot to stand up like this. I think Senzo is fighting wherever he is, and at the same time, Mngomezulu is just backing up. His spirit is still there in court. I could see MNISI doing this, and I saw like Mngomezulu was standing close to him. May his soul rest in peace. Family, what do you think? Do you think the Mayiwa family will get closure? Just drop your comment, and don't forget to like, share, and subscribe. Let's fight the really fight. And let's not forget to keep him in prayer, because the fight is not over. Bravo, bravo.